Good afternoon. Good afternoon.
Good afternoon. Good afternoon.
Oh, you all sound so tired. You all sound very tired tonight. I hope not. Okay, should we just quickly just introduce ourselves? Just tell us a little bit about yourself and your interest in the course. Anyone can start.
Good day. My name is Alicia Kalma. I work at Family Guardian. I'm a senior manager for the mortgages department.
Okay, wonderful.
Good evening, everyone. My name is Janique Turnquest. I'm the Senior Mortgage Administrator at Family Guardian.
Okay,
Good evening, everyone. My name is Dominica Thompson, and I am the Corporate Secretary at Bahamas Law Enforcement Cooperative Credit Union.
okay, welcome.
Good
Sarah,
evening, all.
Go ahead.
My name is Dora May Harvey, and I am a specialized service agent, mortgage and processing officer at RBC.
Okay,
Good evening, everyone. My name is Demetria Cooper, and I'm the mortgage specialist, Northern Bahamas at Family Guardian.
okay. We have Zeno, Cleopatra.
Sorry, good evening, everyone. My name is Xenia McKenzie. I'm a specialized support officer in the Lending Service Center at RBC FinCo.
Good evening, everyone. Hello.
Yes. Is that everyone? Let's see, Alicia. Janine, you spoke? Janine,
Coach.
okay. All right, so if you look at your schedule, you will see the date for the final exam. And normally we just have one exam, but I think for this time around, if you all would agree, we can have a midterm. Would you prefer that, or you just want an exam at the end? Which is what exam?
Would the midterm be made up of multiple choice?
Why is that always a request? That's what you would prefer?
Yes.
Oh, I see. All right, but let's see what the class says. That's for the midterm now, not for the finals. So what do your classmates say?
I agree.
Multiple choice?
Yes, that would work.
Okay, all right, so multiple choice it is then. We just need to decide on the date now. So there are 12 chapters. So should we do it after
Chapter 6.
6? I'm thinking 6, yes, after chapter 6. Everybody agree?
Yes, that's
Agreed.
fine.
Okay, so these from 1 through 6. And then for the midterm,
That's for which time period?
well, we got to do it after 6. So if we do it after 6, it would be. They don't want to skip. If we do it online. I'm trying to see how to fit in. You want to take it on a Saturday? How that sounds?
Which,
We can do it on a Monday during a class session.
Then we're gonna have to double up on a class. I mean, we can.
Can we do it through the week? Day, any other day other than Monday?
We could arrange that with Miguel, yes. So you tell me.
So we have to come into a meeting place to take this exam, yes? Or how
Well,
is
it's
it?
multiple choice. I'm gonna see if he can just do it online.
Okay,
So that's what I'm trying to get from you all a date. So if we could agree with a date, that would be good, or a week. And I could tell him during this week and he could pick the date. That's
I'm-
convenient.
I'm not available from 28th to the 27th of August. I don't know how that works into the schedule.
Okay.
Any particular day you're looking at? I have other sessions. My Thursdays and Fridays are booked, so any particular day you were looking at and time, would it be the same time?
It'd be the same time. I'm not looking at any particular date. That's why I want you to tell me.
Okay, I'm not available Thursdays and Fridays.
Okay.
Well, if we're looking to do the midterm 6 chapters in, I would think that's 6 weeks from now. So then we only got to choose the date.
Yeah, but she already said the 20th.
Yeah, I mean, other than the date that she has indicated, and then that Monday. So we only left with that Tuesday and Wednesday.
Yeah.
Either day is fine with me.
August 1st is a holiday, so we don't have class that day, or how does that work?
No, you have class the next day, the Tuesday.
All right, so Wednesday is only left.
No, but if we go on the sixth class, right? So we go 1, 2, 3, 4.
That'll be August 8th, will be the 6th class.
August 8th. Okay.
That'll be August 8th. So we're looking at,
The 9th or 10th.
no,
The 10th is good.
have it on the week of the 15th.
That's fine as well.
Yeah, the week 15th. So which days are we talking about? Either a
16 or 17.
or 17th.
Can we do the 17th?
It's fine with me.
Okay. So let me,
What day
Fine.
is the 17th? Sorry.
That's a Wednesday.
that's a Wednesday.
Traveling, maybe traveling. Anyway, we'll see. Maybe traveling then that week.
The whole week?
planning on leaving on, but I was saying I could leave on the 16th if we did it on, we do it on Wednesday. So I was leaving between the 15th and the 6th. The Tuesday or the Wednesday I was leaving, but
Well, okay, well, it's
That's-
just you. So maybe he could arrange just for you to take yours.
okay, that Tuesday would probably be better for me. So if I could do it before, that'd be fine.
But it's online. I mean, if it's going to be online, then,
You
was-
travel,
Yeah,
you have to stop and sit,
oh, I see.
she'd want to do it before she traveled.
right. So I wouldn't change your date, but if I could do, if it comes to that, I'll let you know in advance if I'm here or not. I could do like the day before.
Day before. Okay. All right. That's understandable. Okay. Everybody's in agreement.
Agreed.
Okay.
Agreed.
Okay. So that's the midterm chapters 1 through 6. So now let's talk about the final exam. You want the final exam be from 7 to the end or everything?
7 to the end.
7 to the end.
7 to the end.
And no multiple choice this time now.
Could be a mixture.
Oh, Lord.
I second that mixture.
Agreed.
Agreed.
What am I gonna do with you all? Okay, noted. I've noted it. Okay?
Okay.
All right. So I see quite a few of you work in mortgages, so I'm sure you're gonna have lots of comments, lots of your practical experience that you wanna share with the class, and so feel free to interrupt at any point. Have any of you ever studied like at least land law itself?
No.
No? Okay. All right. So let's start with chapter 1. Not that long because it's meant whereby we go over it and then after class, you're gonna sit down and try to understand it. If you have any questions, then you could either email me on the questions or you could wait until next class.
Is it possible for us to get a hard copy of this manual? Or it's only?
Yes, you want one printed?
Yes, please.
Okay, and that was Cleopatra?
No, Indira Hadley.
Oh dear, oh, your name went drop back to the bottom. Hold on, let me put it on here.
Indira Hadley. I can pick it up from the office.
Yeah,
Cleopatra.
Can I have a copy as well, please?
Who is that? Dominica?
Yes, ma'am.
Okay, so I'll,
Let's see.
yeah,
So
I'll,
it's not something that can be emailed to us and we print off then.
That's
Yeah.
a lot of pages.
yeah,
Oh, it's
or
a
you,
lot? Okay.
yeah, or you could just have them printed for you. So that's Indira, Cleopatra, Dominica, who else?
Alicia.
Alicia?
Janique also, please.
Oh, Janique?
And Grace, yes, Janique.
And Demetria.
Okay, I'll let them know. Okay, I'll do that right after class. And let them send you an email. They'll tell you when you can pick it up. So that's 1, 2, 3, 4, 5, 6 persons. Okay. So let's start with understanding Bahamian land law. So the first thing you start off when you talk about land law is you're talking about property. And in land law, property means ownership. So when you talk about property, you're talking about ownership and you're talking about rights. So when you talk about property, it's normally referred to as the law of rights to land. The property also means that which is owned. So when we say property talks about is more or less the law of rights to land, you'll understand that as we go further into this chapter and in the other chapters. So ownership is something that is very hard to define, because when you speak about ownership, you're speaking in law about the right of a person to enjoy a property as fully as the law permits. Or it's a right to assert that something is one's own. And that is a right which is asserted against all comers, whether it's newcomers or it's old comers. So ownership has three rights. It has the right of using, which means that you have exclusive use to that property. The owner may use the thing himself, or he could prevent anyone else from using that property. The second right is the right of profiting from that ownership of property. And that profiting means profits which may be taken by the owner, such as rent or dividends or shares. And the third right of ownership is using up. And that means that the owner can destroy it, he can diminish it, and he can transfer the ownership to another person by sale or by gift or otherwise. Cleopatra, you had a comment?
No.
Okay, so you see when someone has a piece of land, that land is a hilly piece of land, and that person goes and start to bulldoze that land down and start to sell the dirt of that land. Because he has a right to that land, and in that right, he owns that land, then based on one of the trinity of rights, he can use up that land. So try to put in your mind that property refers to the law of rights to land.
Okay.
And when you say you own property, you have ownership, you're speaking about that right to enjoy that property. So it's not the same as when you say you own a pair of shoes. It's a different type of ownership than ownership in property. So with ownership, you can lose possession of it, but you don't lose title of it.
Oh, but okay.
Go ahead, Cleopatra.
No, I mean, how does that work?
You mean how does it work in terms of losing possession?
Okay,
So-
I could understand losing possession of it, but you were
Mhm.
saying not the title to it?
Yes.
I'm sorry, didn't hear you.
So you can have title to a property, and someone else can be living on that property.
Okay.
So losing property that one merely possesses means that you lose physical control.
Okay.
Would that have anything to do with joint tenancy? Like husband and wife?
No, that's not joint tenancy.
That would be with,
We'll get to that.
would that be squatting?
Could be, yes.
Okay.
So the class of property rights, we also have other rights. And ownership of a thing can be regarded as a right in or to that thing. So you could own a right over or against a thing that is owned by another person.
Okay.
So in property right, you have easements and you have profits. And you also have restrictive covenants. So an easement is a right over one piece of property or land which attaches to or benefits another person's piece of land. So an easement means that for you to get to your property, you pass over someone else's property. You have that right to walk through. A profit is like an easement. It is a right to go on another person's property and diminish it, which means that you could go on another person's property and remove soil. That's what it means by diminishing it. Be mindful that easements always means that the land is adjacent to, because you're walking through a person's land. So it's one land in front of another or on the side of another one. That's adjacent. A profit doesn't have to be adjacent. Restrictive covenant is a promise that is made in a deed. It's really related to the law of contract, but there are certain conditions that a landowner can put in the deed so that it continues and is enforceable with other success titles to that property. So then it's said that the restrictive covenant runs with the land. And that's why it falls under property law. So when you look at the true nature of ownership, it's entitled rather than ownership when it comes to property. Property law concentrates on the fact of possession. So anyone who asserts that he is being dispossessed of his land or his goods, they don't have to prove that they were the true owner. What you actually prove is that you have a better right to possession than the other person. An earlier right to possession is generally a better right to possession. You understand that?
Okay.
Yes? An earlier right to possession is generally a better right to possession. And possessions means that you have exclusive use and control of an item of property, but with no rights or title to that property. So possession may be evidence of ownership. So a person in possession of property may have continuing physical control over the item and an intention to exclude others from controlling it. In dealing with land matters, the purchaser, they would normally insist on a formal proof of ownership. And that means that the vendor provides the proof by producing title deeds in the form of a certificate of title. The title deeds demonstrate the strength or otherwise of the vendor's title, his right to possession of the land, and it then allows the purchaser to ascertain whether there is any risk that someone else may come with a better claim to possession. So that's why you see a lot of matters that go in the court talking about property and ownership has to do with possession and who has the better title to that property. So when you talk about ownership, there are certain things that are capable of ownership. And of course, as society changes in law, of course, these things will change over time. So land has always been known to be capable of ownership. But there are other things in society that are capable of ownership. Clothes, tools, food, books, cattle, horses, all of those things are capable of ownership. And these things are, well, are physical things, and we call them chattels. There are also other items that are classified under ownership, such as intangibles, copyright, shares, debts, computer software. Those are intangible. So when it comes to property, the law of property is divided into two categories: real property and personal property. Real property is where you have a freehold interest in land. And freehold means that you own it absolutely. There are no claims against that property. Personal property is comprised of both tangible and intangible property. And these are not considered freehold interests. So personal property can comprise of leasehold interest in land and other chattels, such as boats and cars and jewelry and furniture. So you understand what leasehold interest means? Yes?
No.
Okay. So if you own, you have ownership title in a piece of land. You own it fee simple absolute in possession, which means there's no liens against that property. You can take that property and you can say, Alicia, you would like to occupy this property for 20 years. Don't forget now, you own that property. You have the title to that property, but you can allow someone else to utilize that property for a certain term. So if Alicia wants to use that property for 20 years, then you would draw up a lease agreement. And she could stay on that land and use that land for 20 years. So let's say during that 20 years, in the 5th year, there is a hurricane. She loses all her crops. And she says, guess what? Cleopatra, I don't want to farm on this land anymore. Are you interested in using this land? So Alicia would have gotten a lease for 20 years. 5 years has passed. So that means there's 15 years left on her lease. She can only lease it to Cleopatra for 15 years. She can't go beyond 15 years because that's all that's left on her lease. So she can draw up a lease with Cleopatra for 15 years or 12 years or 10 years. So let's say another hurricane comes. Cleopatra in turn can then lease that land to someone else for the term that she has left in her lease. And that's called a leasehold interest. So chattels personal, such as cars, boats, and jewelry and furniture, they are divided into two. They're called choices in action and choices in possession. Choices in action is property which doesn't physically exist and it can't be possessed. So an example of that is copyright or a patent or goodwill. Choices in possession are personal property with a physical existence. So that's books or clothes or computers. In the financial sector, security for banks, legal or equitable charges are normally taken by banks over choices in action for loans. So that could be shares, could be guarantees, could be life insurance policies, it can be debentures. So you see, when it comes to property, property can be divided into real property, then into personal property. Personal property can be tangible or intangible. Then you have chattel real and chattel personal. Chattel personal can be divided into choices in action and choices in possession. So let's turn now to land. So land in legal terms can include real property, the buildings, and any structures on the property, and the rights over land. Rights of way, easeway, mining rights. Land does not include fixtures which are not attached to the land or the building constructed on it. If, for example, paintings or furniture, or growing crops, if they are severed from the land whilst harvesting. So land, realty, or real property is distinguished from personality or personal property. They're two different things, especially when someone writes a will and they are disposing of property versus personality. So land law relates to the rights over land rather than to land itself. Everybody understands that? So you don't own the land. You own a right over that land. So to make it even clearer, when a person mortgages their freehold land to the bank as security, what he's actually doing in effect is he restricts his freehold rights of ownership by giving the bank rights of security over his land. And he does that either by a legal or equitable mortgage. The land is not affected. Only the rights over the land are. So those dealing in mortgages, you understand that?
Yes.
Yes.
Okay,
Yes, I got that.
okay. So let's look at legal and equitable rights. There are two types of rights over land: legal rights and equitable rights. Legal rights can either be legal estate or legal interests. A legal estate is a type of right of ownership which gives the owner an entitlement to possess or occupy the land. And that's what we call a freehold ownership of land. Legal estate has two forms. One is freehold estate and the other one is leasehold estate. Freehold estate, the freeholder owes no obligation to a superior tenant in respect of his or her land holding. The estate is known as, like I mentioned before, fee simple absolute in possession. So when you look at a mortgage deed, it tells you, you'll see those words, fee simple absolute in possession. Fee simple means an estate in land which can endure indefinitely and pass either by sale or by gift, by the freeholder, or by will, or under the rules of intestacy to another person. You know what intestacy means?
No.
No,
Okay, so
explain that a little bit, please.
okay, so when you own a piece of land, you have an interest in that land, and if there is no debt against that land, you own that fee simple absolute in possession. Fee simple means that your estate in land can pass because you don't owe anyone on that land. It can pass by will, which means you can write a will and you can say, I devise my property situated in Eastern District on lot number 45 and 46 and 47 on the boundary of this, and this to my daughter, so and so. Now, if you die without a will, that means you would have died intestate. When you die with a will, you die testate. So if you die without a will, then the laws of the Bahamas will then determine who obtains your land or whatever assets that you leave behind. So if you die without a will, you die intestate, and the distribution of your assets will be done under the law of inheritance. Any questions there? Everybody going quiet. What does that mean?
No, I understand that part.
Okay, so you know what happens on intestacy.
That means there's no will.
Yes.
Okay, so then the law
So they
of
would
the
get a
land,
probate.
no, the law of the land from the courts would prevail then.
They follow the Inheritance Act.
Does that tie in with like a probate?
You will get letters of administration rather than the probate. When a person dies, the persons who are responsible for administering the estates are collectively called personal representatives. If you die with a will, then that person is called an executor because that person is named in the will. That person takes action immediately upon death. If you die without a will, then an administrator is appointed by the court, the probate court. So that means that a person cannot take action until that is granted by the probate court. The distribution of your assets will be done according to Part 2 of the Inheritance Act. So if you did not leave a will, you left a husband with no children, he gets all. If you left a husband and you left children, he gets 50% and the other 50% goes to the children. And the law goes on. So that's what's referred to when it speaks to rules of intestacy. Understood?
Yes.
Okay. So absolute means that it is unconditional and in possession. That is that the freeholder is either in actual possession or he has the right to receive rent and profits. So this, let's say if he has property and he has a house on it, but the house is being rented. But he has it absolutely, because he is still the freeholder. And he's still in possession because he could ask them to leave his premises. Now, leasehold estate is where the tenant derives the estate from a superior tenant who can be a freeholder or another leaseholder. And that's the one that I explained to you earlier when you asked, what do we mean? What does leasehold mean? So the freeholder can lease to a tenant, and that tenant can lease to another tenant, but he can never exceed that. So notwithstanding the leasehold agreement, the freeholder still has his freehold interest during the continuance of the lease. So once the lease is finished, then it reverts back to the freeholder. So the leasehold is referred to as the terms of years absolute. And all that means is that the leasehold may last for a fixed period of time unless the leasehold terminates due to forfeiture or breach of a term of the lease. So fixed term leases of certain duration are the only leases that may be useful as security. So an interest in land is a right to a claim against the land of another person that is less than a claim to possession. So interest in land can either be legal or equitable interests. A legal interest is a right over land which is given to a non-owner, but is still valid against everyone. And it gives the non-owner a right which is less than actual. For example, a permanent right-of-way over a neighbor's land, which gives the non-owner the right to cross the neighbor's land, but not take possession of it. So some examples of legal interests are an easement, which we discussed earlier. It could be a charge by way of legal mortgage. It could be a rent charge. It could be a charge imposed on the land by law, or it could be a right of entry. An equitable interest are legal rights which are valid against anyone who has notice of those rights. And that notice could be actual or constructive. For example, a bona fide purchaser for value of property who purchases the property without genuine notice of the equitable rights over the land may acquire the property free of those rights. So some examples of equitable interest is the equity of redemption. And the equity of redemption refers to a right of a mortgagor to redeem the mortgage property upon payment of the outstanding principal. An equitable charge is interest in land taken as security for a loan without creating a formal legal charge. And of course, restrictive covenants. These are agreements or undertakings where one person promises to restrict the use of their land for the benefit of another person's adjoining it. So when you talk about ownership and you speak about legal and equitable ownership of a land and that legal interest, the legal ownership in land gives legal title to the estate, and the equitable interest gives the right to benefit from the estate for the beneficiaries. So you would see this split between legal and equitable interests where there is a trust. Due to the nature of legal and equitable interests, it is possible for one person to be recognized as the legal owner while another may be the equitable owner of the same property. Does everyone understand a trust and how it works? Everybody understands a trust?
No.
Okay, so a trust over land.
Right.
An individual has title, fee simple absolute in a piece of land. Fee simple absolute, like I said, means that there is no sums on that. Now, when you have fee simple absolute, you have both legal and equitable interests in that land. To create a trust, that person has to transfer the legal interest in that property to a trustee. The equitable interest is then given to the beneficiaries of that trust. That equitable interest gives the beneficiaries the right to sue the trustees. So the trustee is the legal owner and the beneficiaries are the equitable owners. And being an equitable owner, then they have the right to the dividends or the profits from the use of the land as beneficiaries. So in a trust, the legal and the equitable interests are separate. The legal owner can dispose of the legal interest, and the equitable owner can dispose of the equitable interest. So the legal owner can create a legal or an equitable mortgage. And an equitable owner can only create an equitable mortgage over the land. So we've spoken about ownership of land and the interest in land. Now we have to speak about co-ownership. So ownership in land can be owned by more than one person. So where two or more persons hold an interest in land at the same time, that's referred to as co-ownership. And that co-ownership can be joint tenancy or tenancy in common. So joint tenancy is where two or more persons each own the whole interest in the land and they don't have separate or distinct shares in it. So it prohibits any one owner from having any exclusive possession of the whole or any part of the property. The key thing about joint tenancy is the right of survivorship. It gives an automatic legal right to the whole interest in the property to the last remaining survivor of all the co-owners. So when a joint tenant dies, his interest lapses and the land is then wholly owned by the survivor. You can't have more than 4 legal joint tenants of land. A tenant may not sell or mortgage his legal rights, as the legal joint tenancy cannot be severed in law. But a joint tenant may sell or mortgage his or her equitable rights. A tenancy in common exists when there's two or more persons who own the land jointly, but undivided shares. So that means that each owner has a share in the land, which may be equal or unequal. In tenancy in common, there is no right of survivorship. So if one co-owner dies, his or her share in the land does not go to the other co-owner. It passes to his personal representative. And remember, I said personal representative is the collective term for the person who executes the will or administers the estate of the deceased. So we know land can be in joint tenancy or it can be in tenancy in common. So let's look now at land registration. In some jurisdictions, land registration is what we call registered land. It's automated. There's not all of this search. You just key in the property or key in the person's name and you automatically get a listing of all the properties that they own. But in the Bahamas, our land law is based on unregistered system of land ownership. So the freehold title to land is denoted by possession of title deeds. And that possession of title deeds consists of abstracts of title, conveyances, mortgages, release of mortgages, searches, assignments, and a schedule of listed documents. The collection of the deeds and the title documents must show a chain of title, concluding that the vendor of the property is the last legal owner of record. In an unregistered system, an owner of land transfers his ownership by deed. So that's a written transfer, and it's usually done by a sale of the land, even though it can be done by gift. So the purchaser or a mortgagee investigates the seller's title and any other matters that may affect the title or affect the land itself and the value before purchasing or lending, whatever the case may be. So title to unregistered land is not only shown by possession of title deeds, but also by the seller demonstrating to the purchaser or the attorney that he has title by showing what we call good root of title. And that means going back at least 30 years. So the transfer of title to land in Bahamian law is a two-stage transaction. You have the agreement for sale, and then you have the conveyance. So the agreement for sale or the contract for sale, it binds the vendor and the purchaser to complete the transfer under specified terms and conditions outlined in the agreement. The agreement does not transfer the title to the property. Under the agreement for sale, the vendor must produce for the purchaser or the purchaser's attorney an abstract of title, showing evidence of title which goes back 30 years. The root title may be a conveyance, it can be a mortgage, or it can be an assent. The conveyance, which is the second part, transfers the title to the legal estate from the vendor to the purchaser. The conveyance must be made by deed. So under Bahamian land law, there are certain pieces of legislation you should get familiar with. One is the law of property and conveyancing of the Condominium Act. There's the Conveyancing and Law of Property Act itself. You have the International Persons Landholding Act. You have the Registration of Records Act, the Real Property Tax Act, the Stamp Duty Act. You have the Value Added Tax Act and regulations. You have the Quieting of Title Act. You have the Borrowers Protection Act. You also have the Construction Act. You have the Environmental Act. All of those pieces of legislation govern property law in the Bahamas.
The last,
The Borrowers Protection Act. Oh, I forgot one. You have the Credit Reporting Act. You have the Environmental Impact Assessment. Or just say the Environmental Act. Environmental Planning and Protection Act, that's what it's called. And then you have the Construction Contractors Act. And you have the Homeowners Protection Act.
Hi, Ms. Archer.
Yes.
Would the recording be available, like if you want to go back and listen to this, or is
Mhm.
there a PowerPoint that,
No,
or would all of this information that you're presenting, it's in the notes that the copies that we're going to collect from the office?
yes. But the
Okay,
will also be available.
all right, great. Thanks.
Okay. So that's the end of chapter 1. I normally don't go further than that. What I will do now is I'm going to send you some case law, Bahamian cases. And I would recommend that you read those because after a while, you're going to become overwhelmed. Because you're going to say it's too many cases to read. But if you read them as we go through each chapter, then you begin to appreciate land law and the difficulties that we face in having unregistered land. So we talked today about land, interest in land, ownership. We spoke about having good root title, because that's what a lot of mortgages about. Making, even when you're just purchasing just land itself, you always want to get root title. And so I'm going to send you some cases. I'm going to send you one on adverse possession. Remember someone mentioned earlier squatters. I'm going to send one on adverse possession. And I'll also send one on root title. So you could begin to read. Now they are not short. So I'll warn you now. They're not short. So you need to take your time and read it before next class, because we'll begin by having a discussion on those cases. And then we'll go into module 2, which is understanding the conveyancing process. That's where we go more into the title and what's required. And then those who do this every day, if there's any changes or any comments that you want to add, feel free. But we'll look at some cases from the Supreme Court on quieting of titles.
question,
Yes.
root title, if it adversely goes back more than the 30 years, do we have any case laws involving that?
Going back further than 30?
Yes, ma'am.
No, you stop at 30.
Okay.
Yeah, it's either 30 years or you could have a quieting. You stop at quieting. And so the different stop, I'll see if I can find more than one type.
Okay.
Yeah. There's normally 30 years or a lease or grant by the crown. Well, of course, a certificate for quieting of title. I'll see if I can find one of each. I'm not sure if I have one for going back 30 years, that far. But let's see what I could find. So I'll send you all about 2 to 3 cases to read,
Okay. Thank you.
okay? And then we'll go into module 2 next class. So what you need to do now is, if you have the book, you could read it over. And then for next class, we will discuss the cases that I send you, and then we will go into module 2. And then as we go further into the units, I'll be sending you more cases. So you need to keep up. Otherwise, like I said, you begin to feel overwhelmed, especially when we start to pull, have a look at the Homeowners Protection Act, the Environmental Impact Act. And then you're gonna start to hold your head and say, oh Lord, it's too much. Okay? So we'll take it slow. We'll take it slow, and then we'll go through the cases next class and then unit 2. All right?
Yes, ma'am.
Yes, ma'am.
Yes.
Right. So let me see if I can start to pull those cases together so you can get started on your readings. All right?
All right.
Thank
Okay.
you.
Have a good evening.
You too.
All right.
Evening.
All
You
right.
as well. Thank you.